Let's get started.
Welcome to the Financial Purpose Podcast. All opinions expressed by me or guests of the podcast are solely our own opinions and do not reflect the opinion of Life Moves Wealth Management. This podcast is for informational purposes only and should not be relied upon for any investment decisions. Clients of Life Moves Wealth Management may maintain positions in the securities discussed in this podcast. Hey, welcome back to the Financial Purpose Podcast. I am your host, Dale Shafer. This is episode 91, and this podcast episode has a partner blog post at lifemoveswealth.com. You can go check out on it. It's the most recent insights article posted. It's called The Costly Mistake of the Uncoordinated Estate Plan. And you thought I was going to say like the uncoordinated tennis player or something like that. Or like me, maybe the uncoordinated golfer, whatever. But this is the uncoordinated estate plan. And this topic may at the start of it sound like maybe hard snooze fest, but it is incredibly important. I don't want you to actually sleep on this topic. This is something that everybody, especially business owners, need to be thinking about, and advisors need to be coaching toward, and estate planning attorneys need to be helping clients resolve. So if you're a business owner or a high net worth individual, you've likely spent time with attorneys and CPAs and your financial advisor to build an estate plan. You probably have things like a trust and a will, insurance policies, powers of attorney, business agreements, maybe even a buy-sell agreement, and all of those documents, having those in place are a great start. But here's the issue. Just having those documents is not enough. It doesn't completely do the job, especially if your estate plan is built in silos. And that's often what I see. They're not, the individual documents are not reviewed together. They're not cross-referenced. And when they are siloed like that, they can end up conflicting with each other. Sometimes your buy-sell agreement can conflict with your operating agreement, and your operating agreement can conflict with your trust and vice versa. And that can lead to a lot of issues, which can make things like avoiding taxes and avoiding family disputes and avoiding costly legal problems very difficult to do. And so I want to talk today about some of those situations. I have a couple of examples of things that I've seen, certainly things that have been written about too many times. And they're written about because they are cases where a little bit of planning, a little bit of coordination probably could have resolved a lot of the issues that these families ran into. So here's a few, I'm just going to jump right in, a few real world mistakes that could have been prevented with a little bit of planning. The first one is the outdated beneficiary. This happens more frequently than it should. But the way it works is like this. The client's will left everything to the current wife. But an old 401k still listed his ex-wife as the beneficiary. Now, the client dies. Current wife is expecting to receive that inheritance for her lifestyle support. Come to find out, a chunk of it is going to a completely different person, an ex-spouse. And the reason that happens is because beneficiary designations override the text in a will in probate court. Now, that can be contested, but beneficiary designations almost always win. And a very simple update could have avoided a very painful and very permanent mistake, because imagine how the widow feels about having part of the husband's legacy and estate go to a former spouse. Now, these kinds of things happen all the time. When a divorce occurs, the beneficiary designations need to be updated. When children are born, beneficiary designations need to be updated. One area where this happens sometimes is if it's a second marriage or even a first marriage where one of the partners brought children into the marriage. If you make the spouse and then the children, including stepchildren, beneficiaries, and then there's a divorce that later occurs, you're going to want to probably update those beneficiary designations unless you still want those children to receive money on a contingent basis. Beneficiaries being outdated, again, happens all the time. This is a place where people can accidentally be disinherited, and it's not much fun, and it is a very emotionally painful mistake. Another example, the buy-sell time bomb. So if you're a business owner, this one's for you. Business owner died with a 15-year-old buy-sell agreement. Glad that they had one written, but it was based on an outdated or earlier valuation. Now, the agreement forced the sale of his shares at a fraction of the current value when he died, and there was no life insurance in place to fund the buyout, and so his family got far less than what they should have, and because there was no funding in place, they even had to wait years to be paid out. Now, I want to break this one down because when there is more than one partner in the business, the first thing that you need to do is have an operating agreement written. And that operating agreement is going to express a lot of things about how the business is running. It's going to express what happens if scenarios. So it's going to be things like what happens if one of the partners die? What happens if one of the partners gets divorced? What happens if one of the partners wants to be bought out? What happens if we bring on an additional partner? All those what if scenarios get spelled out, and you all agree on how you're going to approach those individual situations, and it puts some legal parameters around what happens to the business and what happens around the business if any of those events occur. Then, after you have your operating agreement, it's often a great idea to have a buy-sell agreement in place if you can. Typically, that's going to be secured or funded by insurance. So you're going to have cross-purchase life insurance policies on each other, so that in the event that one person dies, that money immediately comes to the business. You're able to pay the family and redeem those shares and then restructure the ownership of the business. Oftentimes, these buy-sell agreements are written, and they're just a promissory note. Basically, there's no funding in place. There's no insurance. There's no separate account with money set aside in it to be able to execute the buyout. And so that can be very, very difficult for the family because they may not be able to get access to any money that they would need to go ahead and continue that owner's lifestyle. Sometimes the business may just continue to pay the salary, but pay it to the family and structure that as part of the buyout on some sort of a promissory note, and that can be possible. Sometimes that doesn't happen, and it really depends on how healthy that partnership was. It also depends on how the operating agreement was written. So it becomes really important for buy-sell agreements, because the one thing that we never know is when those are going to be executed. They will all be executed at some point, unless the entity goes out of business and it all becomes null and void anyway. But at some point, there's going to be a change in the business. Somebody's going to die. Somebody's going to have a life event. Somebody's going to want to be bought out. Somebody might come in as an investor and have partnership interest. So you have to have the documents in place, which is a great first step. But as I said, you also then have to have a funding mechanism in place. Example number 3, the trust that ignored the tax plan. Here's the scenario. A couple, husband and wife, or whatever structure that looks like for you, started gifting assets to their children and funding a family investment account. But none of it was coordinated with their trust or their tax advisor. Now, trust typically has very specific language for how assets will be distributed upon the death of the first spouse, and usually after the second spouse passes away. That's when the full trust execution happens. But the couple's gifting money to the kids, and there's no coordination with how that works for the trust and how it works for the tax bill. When the second spouse passed away, confusion over ownership of the assets outdated trust language because it didn't reflect the current state of the assets because it had already been in distribution. It caused delays in being able to distribute the trust. The IRS got involved and audited the trust. They lost their step up in basis on some of the assets because of the way that they were gifting. And it created a very large and unnecessary tax bill for the kids, which is who that trust was set up to benefit anyway. And now the the children bear the burden of an inefficient trust, which creates a now inefficient tax bill. And none of these situations are rare occurrences. As I said, we've seen them. They get written about a lot. Other advisors talk about them. There's a group of advisors. Sometimes we get together and we shop talk and we share these examples of things that happen to our clients. And unfortunately, we hear about versions of these or some sort of variants of these all the time. Again, having the documents in place is a great first start, but there's going to be some things that once the documents are in place that you want to do, because if you don't have the documents in place, these are not we'll deal with it later type issues. These are critical risks that can they can undo years and sometimes even decades of effort and planning and cost to have the documents drafted and maybe revised down the road. But all of these situations, the trust that ignored the tax plan, the buy-sell bomb, the unplanned beneficiary, all of those things are almost always preventable. And so I want to talk through a couple of ways that you can avoid these kinds of costly mistakes. And these are very straightforward. They're very easy to do. They're not complicated steps to take, but if you don't take them, they create a lot of complication in the estate plan and in the business continuity plan. So the first thing that you need to do and should be doing regularly is updating your documents. Now, life changes all the time, or as I like to say, life moves all the time, which is literally why Life Moves Wealth was named Life Moves Wealth. It's not that creative. It's just an action. It's a verb of how life moves for people. Things are always in motion. And so we want to be a part of that. As it's changing, we want to have an active role there. So your estate plan documents should change as well as life is adjusting and moving and things are shaking. And that typically looks around events like marriage, divorce, business growth, grandkids, selling property. Each one of those kinds of situations, buying a business, selling a business, taking a partner, all of it, each one is a trigger to review and potentially update your plan. Now, at Life Moves Wealth, we review our clients' estate planning documents by rule about every 3 to 5 years or sooner if any of these life events are happening. I have a pretty good idea if something is happening in my clients' lives that we need to go talk to an estate planning attorney. And sometimes it's things like we need to update your POA, or we need to update your healthcare POAs, or, we might want to change the language of the trust, or we might want to update who's named in your HIPAA document. Did you know a HIPAA document is part of a good estate plan? It is. And it's a standing HIPAA that can be sent to all of your doctors and hospitals, and it helps them understand who needs information about your health in the event that you're unable to advocate for yourself. And those are very, very important. So we're going to know when those things need to be updated. We're going to make a suggestion. We're going to help you get in front of the estate planning attorney, serve as an interpreter, let the estate planning attorney use their expertise to structure the correct method and documents and process for how those wishes of yours are expressed and protected legally. But we're going to go and be part of the conversation because we understand you and what you're trying to do. I know a lot about my clients. There may be questions that they don't know to ask or things that they don't remember to think about or to think through. and I just may have a pretty good sense of what to do there. So we take a pretty active role in the estate planning process. The next thing that you want to do is centralize or bring it all together, all the planning. So it's not a good idea to let your CPA be a silo and your attorney be a silo and your financial advisor be a silo. You want to coordinate all of those all of that advice is what I meant to say, advice and decisions. And I love bringing all the professionals into one room together to sit at the same table to whiteboard the issues or do the math or talk through the considerations, especially when there's a major decision or a potential risk that's on the table that we need to guard for. As I said a couple of episodes ago, I just did this earlier, or I should say actually at the end of the month of June, flew into a city, CPA flew into the same city from another place in the country. We all met in the same room and we sat there for a few hours and had a good planning session, brought in lunch, whiteboarded the all the topics and considerations for the things that the client is trying to work through and set up for the next stage of their business. And it was a fantastic meeting. The feedback all around was it was time well spent. It was incredibly valuable to have everybody together. It was the type of work we could not do on a Zoom call. And it was so valuable, and the decision is so large and has so many moving components that now we're probably going to move to a semi-annual all people in the room meeting to continue through these decisions and the next steps over the next 3 to 5 years that this client's going to take. And that's high value stuff. Those kinds of meetings are way higher value to you as a business owner than somebody who just wants to talk to you about rate of return or the next hot stock or what's happening with the dollar and whatever. All of those things are important, and I want to have those conversations too, but they're low value. They're low value because that's not information that only I can provide. That's not value that only I can provide. You can go on Yahoo Finance or Google or thestreet.com or Wall Street Journal or Koifin or whatever you want to use, and you can pull up all this information. You can see what stocks are doing. You can see how the dollar is trending against the yen or the euro or whatever. And I can answer questions about that, but it's low value because what's higher value is all the big time decisions that you need to be making that impact your life, your cash flow, your business, your risk management, your retirement planning, as I always say, retirement, whatever that means to you, your estate plan. Those are the high value conversations. So that's where we want to be. Getting everybody into the same room and centralized on the marching orders, very important. And it helps you think through multiple perspectives because I'm going to come at a problem a little differently than the CPA will. Both of our perspectives together, boom, massively advantageous for the client. So you want to get your professionals together working on the same problem the same way so we all understand what to do next. The next thing that you can do is double check your beneficiary designations. And I talked about this at the front of the episode with the example of the accidentally disinherited spouse. And the beneficiary designations, this is what happens when I try to talk too fast. My brain's going fast. My mouth is trying to keep up and we glitch. So the beneficiary designations control where retirement accounts and insurance go, regardless of what your will or even your trust says. So we need to revisit the designations every year, and at Life Moves Wealth, we do. We revisit designations. It's part of our annual planning process. So we meet with our clients multiple times a year for the most part, and then we have an anniversary meeting. And that's just around the time that they originally became a client. And as a part of that anniversary meeting checklist, we are making sure that we've checked the beneficiary designations, that we have the current estate plan on file, that we've reviewed the estate plan and whether or not there are updates that we need to suggest based on things that have happened, or if the client wants to make any changes based on what they're dealing with. And there's a lot of other things that we check through. And then we celebrate progress, and then we talk about what's currently happening with all of the accounts and cash flow, and we go through our Elements dashboard and help them understand how they look from a financial health standpoint, and then we do what's next. What are the next 12 months of planning? What does that need to look like? What are we working on? What's most important to accomplish? And then off we go. And then we start the new year and the new planning cycle. The beneficiary designations have to be reviewed annually because things change and people change and you change your mind. And maybe you change the percentages of people, especially if you have multiple beneficiaries. Maybe that gets moved around, especially in the event where you lose a spouse or you get a divorce. Immediately after that happens, we want to make those designation changes just to make sure that what you've worked so hard to save and invest gets to the places and the people and the organizations that matter the most to you. Even if that's changed, let's update to reflect your current wishes. And especially when a trust is part of your plan, this is very important as well. As a beneficiary designation, we want to make sure that the trust is funded with the correct assets, or that POD's bank accounts point to the trust as well. Or we could even have bank accounts and investment accounts owned by the trust. Homes can be owned by the trust. Very important assets like that can be owned by the trust. And sometimes, things like the car that you drive every day, maybe that doesn't get owned by the trust because you may not own it long enough. People trade in cars every couple of years, and so that just becomes meticulous from a paperwork updating standpoint, and it's just another legal fee and whatever. But if you have collector cars, or if you have, an account where there's commodities or crypto or things like that, we want those things to be controlled by the trust so that they don't get held up in probate court, and then the family has to go and you have to pay the court fees and the administration, and you have to go before the judge and prove ownership and all of these things. It's just much easier to have the trust own those accounts and assets, or have those assets have the trust as the beneficiary of those assets. Particularly bank accounts can be the easiest way to do that. So that's another part of what we're doing. So if I know that there's a trust established, most of the time that's because we've done the estate plan with the client, we've established trust. My job is then to help it get funded and to get clients to take the steps necessary to fund the trust in the right way. The next thing that's on the list that you can do is revisit your business agreements. This should be done often as well, for the same reason. Your business today does not look the same as it did 5 years ago, or especially 10 years ago, or even longer. So your business agreements probably shouldn't look that way either. They probably need to be updated, and we would recommend a business valuation every few years and a fresh set of your buy, sell, and operating agreements after periods where the business has had sizable growth, or there's been a partnership change, or a key personnel change, or the business is slowing down, or considering an acquisition target, or possibly being acquired. All of these things would prompt a business review and a business agreement review. And so we want to do those things. The business valuation is important to do every couple of years because it helps you reset what your ownership shares are worth. And that becomes important because if you start with a very small percentage of ownership or ownership value and you become wildly successful, it's very possible that there is a difference in how that business should be ran, into where the value should be assigned and who owns what number of shares and what those shares are valued. You want to get that documented so it's not ambiguous. So ambiguous. Did I really say that? Ambiguous. So we don't want that to be confusing, because that sounds like a court case, and you don't want to be sued by a former partner, because bad blood becomes bad, even worse blood. And then there's a Taylor Swift song, I guess, about that. But nobody wants that for themselves and for each other, really. The attorneys love that stuff, but you don't have to pay those fees. Let's pay the attorney while everybody still likes each other, because it costs less, and you can do better planning that way. And so revisit the business agreements often. Valuations are important every couple of years. I know a business owner who has a valuation done on their business every single year, and it just gets updated and they benchmark it every single year. And that may be too much for your business. Every couple of years might work, but we got to find the cadence that works for you. The last thing that I'd recommend here is to keep a master document file. So this is where you're going to store all of your important documents, especially from an estate planning standpoint, business planning standpoint. You want to make sure that key people know where they live and how to access those documents, and more importantly, what to do if something happens to you. At Life Moves Wealth, we store digital copies of all of these documents for our clients, and we encourage families to share access with the people who are named in their documents. So, for example, if you have 5 people listed on your HIPAA documentation, you might give each of those 5 people a copy of that HIPAA form so they have it on file, so they can go to the hospital and say, this is me, this is the HIPAA form, I want to make sure that you have it. How is Uncle Joe doing? Or how's my brother doing? Or how's my best friend doing? What's the status? That can be important. If somebody is named as a POA or a successor trustee or something like that, maybe you sit down with them and go over those documents in earnest so they understand the duties that they will have to fill on your behalf. Now, remember, and if you don't know, this is important information, but the POA is only valid while the person giving that authority is living. So, for example, if your father or mother makes you their POA, when they die, that POA is no longer valid because the person who granted it can no longer revoke that assignment. So POAs are only as good as the person being alive. And it's important for you to understand what it means to be the POA, what the responsibilities are, what your legal fiduciary responsibilities are in that document. And then what happens if there's finalities? So what happens if the person granting that authority dies? Who takes over as the successor trustee or the executor of the will? And you want to know who those people are. And those people want to know that you've named them in that role because it's a very important role that they will have to play on your behalf and on behalf of your family. So keep a master file. Let the kids and spouse and maybe your business partners know where those documents live and how to get access to them. And definitely make sure that your advisor, your financial advisor especially, has an electronic copy of all of these documents as well. So the bottom line here, I mean, this is not a very long episode. I didn't want to bore you to death with it, but this is a very important topic. You have worked way too hard to let poor coordination sabotage your financial legacy. And it's not about having more and more and more and more documents and paying more legal fees and having a big fat binder. It's about having the right documents that work together and consider each other as a part of a total plan, and that your key advisors understand that playbook. And that's really what your estate planning documents are. They are a future playbook, and everybody needs to understand how to execute that game plan. So if it's been a few years since you've reviewed your estate strategy, or if you're unsure whether your current legal and financial plans and documents are aligned, we should probably talk. Again, I'm not an estate planning attorney. I'm not going to rewrite documents for you. I'm not going to give you legal advice. I can't. But we can talk about estate planning strategy. We can get the right estate planning attorney for you in the conversation so we can get everything aligned. The one thing I will not do, for better or worse, is I will not give you 3 or 4 names and say, here's 3 or 4 people I like, call them and see who you like and hire the one that you want. In my experience, you probably won't make those phone calls, because having to call 3 or 4 attorneys and tell the story over and over again and maybe meet with 3 or 4 of them or have a phone consultation and all of that stuff, it's just not a great use of your time. And it's not a great use of the attorney's time, because now they're trying to bring in business that, who knows? And they know that you're calling 3 other attorneys. They're not going to give you their best. So what I do is I understand you as a person and your personality and the things that are important to you and the complexity of your situation. And then I match you with an attorney that I know well, who would be a good fit for your situation and for your personality and for your wishes. And that has always worked out incredibly well. And clients love that because it's one meeting, maybe 2 meetings when we get to the part where we're signing documents. It's not complicated. They don't have to tell the story a bunch of times, and they get me in the room playing backstop in case there's anything that gets missed or if there's something that they're not sure about or don't understand. And it's helpful for the attorneys because they're not trying to it shortcuts the learning curve of a person that they don't know, that they've never worked with, that I probably have worked with for a while and have a good basis on. So if it's been a few years, if you're not sure if it's all coordinated, let's talk. A second set of eyes might be the best investment that you're going to make this year in your financial planning, other than hiring me and Life Moves Wealth. That'd be a great investment for you. But having your estate plan ordered and orderly and coordinated, also massive investment. So you can go to lifemoveswealth.com and click the schedule time with me button, and we can have a meeting together. You can send an email to info@lifemoveswealth.com and say estate planning review in the subject line, and I'll know that you've listened to this episode, and we'll get together and talk about that and see what needs to be done. Now, if you give a mouse a cookie, it's going to ask for milk. And if it asks for milk, it's going to want a straw. And if you give it a straw, it's going to drink all the milk, and then it's going to want a napkin, and then it's going to want a mirror to see if it still has a milk mustache, and then a comb. And if you've read the book, you know where I'm going with this. It's one of my favorite childhood books that I kind of still like to go read once in a while because it's a great if-then that thinking process. So if you want to do an estate plan review and I'm not your financial planner, I'm probably going to ask you questions about your financial plan, and that's going to lead us down a different conversation. This actually just happened last week. I met with 2 business owners, partners in this business, and we've been in communication for a period of time, and I helped them set up a retirement plan in their business, and we're doing the review for that plan and benchmarking and things like that. And I've wanted to meet with these guys and go through their personal planning because I have a decent sense of the business planning. And so I want to start tying those things together. And the owner says, hey, I just bought this new house, and, the business is growing and the kids, and man, I really need to get my estate plan together. What do you recommend? I was like, I recommend we meet. Finally, we meet, let me look at everything, because if I can't see the landscape, I don't know what to recommend and who to bring in to write the correct documents for you and for the business. And so that started a great conversation with both of the owners who both have the same need. And so that's how that works. If you ask a question, there's probably going to be a lead in for some other things that you need. And it's just a professional hazard. I can't help myself, but you're better for it. You're better for it because I have a curious mind, and that's going to help you get through a lot of the things that you may have questions about. So anyway, info@lifemoveswealth.com or lifemoveswealth.com. I'd love to meet with you. So that's it. Estate planning, very, very important topic. It's very costly if it's not done well. Let's save you and your family the heartaches and the burden of an uncoordinated estate plan. That's what I have for you. And the next episode of The Financial Purpose is going to be really special. I cannot wait to share it with you, and you'll see that coming up soon. So until then, go be a boss. Take care of yourself. See ya. Thanks for listening to this episode. Be sure to like, subscribe, and share. To learn more about your financial purpose, visit lifemoveswealth.com.